Hey guys, this is Peter Hafner, Certified Financial Planner and Certified Financial Fiduciary. And joining us again today is Dawn Myska, Elder Care Attorney, to help us answer all those questions you have about estate planning and all that kind of stuff. So Dawn, thanks for joining us again today.
Nice to see you.
Great, great. So I think today I want to talk a little bit about we try really hard to get POAs on file for all our clients because we have been in situations where someone has some sort of problem or event and it's not on file, and it's not easy to get it on file then. Sometimes I find out people don't have POAs. So we really try hard to get them on file when things are good and people are healthy. But sometimes the people with POAs don't want to sign them and give them to their kids. They don't want executed POAs on file. So I wonder if you can talk about this a little bit, what you've seen in your practice, maybe.
Yeah, so the statute for the power of attorney, it's changed over and over the past couple of years, right?
Yeah.
So just a little quick history. Before 2009, anybody who signed a power of attorney document designating somebody as their agent, the law back then said that agent's authority went into effect the minute the principal signed the power of attorney designating that person as their agent. So that was up until 2009. In 2009, the legislature changed the statute and said, okay, well, now in order for the agent's authority to be effective, the agent is then required to also put their signature on the document, acknowledging their appointment as agent. So that law has been in effect since 2009. Now, any power of attorney signed prior to 2009 is still valid under the current law. Okay, so your agent, if you have a power of attorney, the client signed before 2009, that agent has the immediate authority, and it's always unbeknownst to the principal. That agent has the immediate authority to act on that person's behalf right now. Under the new statute, because the agent has to acknowledge their authority under the power of attorney, a lot of times clients they'll designate somebody, but they are hesitant on having the agent place their signature on the document so that their powers go into effect.
Yeah.
Now, there's ways that you can state under your power of attorney. If you don't want your agent's authority to go into effect, you can hold on to the original document. Our office does not hold on to clients' original powers of attorneys. So if we have a client that, say, designates their son or daughter as their agent, as their primary agent under the power of attorney, and they don't want their son or daughter to become the agent right now, we'll turn that document over to the client, and it's the client's responsibility to keep it safe so that when the parent is now needing help, needing assistance with their financial decisions, then the son or daughter, who's the agent, has to find that document in parent's papers.
Yeah.
Right? And hopefully the parent hasn't, misplaced the document or inadvertently shredded it or thrown it out.
Find is an important word.
Yeah.
Because everyone is not telling their POA, their children, their important people where they keep these things.
Yeah. And power of attorney documents, they're not required to be recorded at the county clerk's office. Okay. The only time the documents are required to be recorded at the county clerk's office is if the agent is buying or selling real estate on behalf of the principal.
Oh, interesting.
Yeah. And then in that instance, the power of attorney must be recorded. But other than that, no, it's really the client's responsibility to safekeep that document.
So we have just started something where we're trying to help our clients get more organized with all their important documents. But essentially, it's a binder, and we are walking through all the various steps to help our clients fill this binder with everything from investment statements to life insurance policies to powers of attorney and all that kind of stuff. So then all you got to do is say to your son or your daughter, whoever,
Look for the binder.
this, yeah,
Look
this
for
is
the binder.
I keep it here in the bookcase. Everything you need is in there.
So another way, because again, I understand the hesitation with the parent letting son or daughter, have the immediate ability to, nose around their financial holdings, right? I get that. I understand that. I mean, under the power of attorney, under the new law, the statute from 2009 forward, the principal can appoint somebody to monitor the people that they've designated as their agent, okay?
Okay.
And sometimes clients say to me, well, we have 3 children, so we're going to appoint oldest child as the primary agent, second oldest child as their substitute, and then we'll appoint the youngest child as the monitor. And I'm like, I don't really think you want to do that.
That sounds like that could cause trouble.
It can. And the monitor has no, the monitor doesn't pay any bills for the principal. They don't do anything like that. They do exactly what that is. They monitor what
sounds like a good job for the youngest child, though.
Yeah.
Speaking as the oldest in my family.
Yeah. And here's
no offense, Joe, not you.
And here's the catch, though. So if you designate a monitor,
right,
the monitor requests everything that the agent did on behalf of the principal. So if they paid a bill, made a phone call, so the agent's going to have to keep records, keep logs, and turn those records and logs over to the monitor.
Right.
And, Pete, that's not going to happen, right? That's not going to happen.
Well, what is, it sounds very adversarial,
It is.
Good for government, I guess, to be on each other's back, but maybe not for a family.
Yeah, exactly. And I have seen it where, a monitor has been requesting documents from the agent on behalf of their, elderly parent. And the agent was, blowing them off, dismissing them.
Yeah.
And the monitor got really upset and they took their job seriously. And the monitor took the agent to court.
Yeah, well, that's the next step if you got a problem, right?
Yeah, exactly. So sometimes clients also mention to me, all right, well, we're going to appoint, our children, but we don't want their powers in place. Can't we do what's called the springing power of attorney? So that's where you state under your power of attorney that your agent's authority, who you designate, that their powers do not become effective unless and only until 2 physicians determined your mental capacity, which of those physicians are, who those physicians are, right? So the law previously did provide for springing powers of attorneys. There was actually a separate document called a springing power of attorney for clients who didn't want to give their agents the authority right away. Legislature did away with that. If clients, say that to me and they want that provision in their current power of attorney, it's possible, but then I have the conversation with the clients. Okay, If we have to say, as determined by two physicians of your inability to manage your finances, who are those physicians going to be, right? Your primary. Well, hopefully you've been going to your primary regularly and that they're familiar with your medical history. And then who's going to be the other one? A psychologist, another non-interested physician who doesn't know you. And the thing is, with doing springing powers of attorneys, putting that language in current powers of attorneys, you may run in a situation where your agent needs to immediately answer or address something or act on your behalf today. And if you're waiting around to get physicians to, sign letters, to meet with you, meet with the principal, determine their mental capacity, you're going to have a delay. And it always is Murphy's Law. It will happen on a Friday at 4:55 p.m. on a long holiday weekend. That something needs to be done by your agent.
All right. I never heard of a springing POA. I've never encountered one. So there's not a lot of them out there, I guess, number one.
No. And it was under the old statute, under the old New York state law that did allow for springing powers of attorney. That law is no longer written, but it can be, you can have that direction still under your current power of attorney. Just got to be very, and I tell clients this, you have to be generally specific or specifically general, especially as a lawyer, right? You don't want to, paint something in a corner and then your hands are tied, but then you don't want to, leave that corner open. It's one of those fine lines, right?
Yeah. One of my favorite sayings is the road to hell is paved with good intentions.
Yeah, exactly. Yeah.
And I can see how that can happen. Hey, one thing I encountered on a POA, which was really unusual, is there were two agents and they had to act together.
Oh, yeah.
Is the way it was done. And it looked like a mistake on the POA. It actually turned out it was a mistake. One lived in Washington State. The other one lived here in Buffalo. Mom's like 85 years old. So it's problematic for both of these people to act together all the time. So I just wonder, is that a common practice to have two agents that have to act together as a way to hopefully protect the person's interest? Is that something that's more commonly done?
And very, very rarely with the powers of attorneys that I prepare for clients, clients do ask for co-agents under the power of attorney. But this is where the conversation with the client and the lawyer really has to get into a lot of detail about the pros and cons, as you just said, in your situation, when you have co-agents and they have to act together as opposed to acting independently of each other, especially if a co-agent doesn't live locally. And sometimes clients think, well, we'll have co-agents with the authority to act independently, again, just like how you said, so that they can keep an eye on what the other one is doing. I mean, that's okay, that's perfect. But hopefully that both of those co-agents, even if they're acting independently of each other, that they have a relationship with each other, that they can communicate and delegate responsibilities to each other, and not have one being in charge of everything. And sometimes the family dynamic, sometimes it doesn't work that way.
Right. So best case scenario, let's say mom's a widow, she's got a couple kids, everyone trusts each other, everything's good. You do a POA, the agent signs off on it, it's executed, and everyone's just ready for whenever it's needed. But what if mom what if there's family problems? What if maybe there are two kids, but she's just not really comfortable giving them authority? Because once she puts that POA on the bank accounts and the investment accounts, the kids can call and they can say, hey, I'm the POA, send a check here and here. How can mom protect herself? What's the best thing she can do in that kind of situation?
Yeah, again, if she's designating the children as agents, she doesn't want them to have the authority, then she can retain that original power of attorney without the children's signature, with the hopes that, the children are able to find it when and if it's needed at some point in the future. Yeah.
So she has the document. She goes to see you. She gets the documents made. The kids' names are on it. But she does not give them to the kids to sign. She holds on to them. So what's a good practice for that person? Because that's a good way to go. But like my uncle just had a stroke, unfortunately, recently, so what's the backup that mom has in that situation, so someone gets the POAs to the kids so they can then execute them if she's not able to take that step? Is there a good solution to that?
Yeah, just like how you're putting together, a folder or a binder with clients, all of their important papers, that's what they're going to need. And the children are going to have to know where to find it.
Got it.
And where to retrieve that document. And if the child is retrieving the document for their parent who has now had a stroke, the child, may want to consider consulting their own attorney, before they sign that document, so that they understand their responsibility as the agent.
Wow, I never thought of that.
Yeah.
How can things go wrong for someone who steps up to take on this responsibility to be agent? What's some of the things that have gone sideways?
The saddest, and this is a recent incident 2 weeks ago.
Yeah.
The agent under a power of attorney decided to charge up to substantial, and I need a substantial amount on the parent's credit card. The parent did not know this until the parent was trying to use the credit card. The parent was homebound in a wheelchair, okay? And the parent found out that their child, who was power of attorney, just completely abused their power. So, unfortunately, with the dollar amount that was involved, now there's criminal charges pending.
Wow, it's a sad story. All right, Dawn, this has been very interesting. Do you have any other thoughts before we go for today on the topic we've been having a discussion about?
Yeah, and I know, this sounds, really scary, what we're talking about here. The power of attorney going bad, the agent going bad. Very, very scary. But it's very important also to have that document. Because if you are in a situation that something needs to be done immediately, well, now somebody can step in, and hopefully that person, that you choose is very, very responsible.
Yeah.
Okay. So get those documents in place.
Yeah.
Okay.
You don't have a POA. It's going to be tough to get one if you're in the hospital unconscious, or if there's some other thing going on.
If you're in the hospital unconscious, you don't have a POA, now, unfortunately, your family is bringing a guardianship.
Oof.
And you're not going to have any ability to do anything on behalf of your parent until you're in court. And
it's a court-appointed guardian, right? Yeah. It's not a friend. It's not a relative. It's not someone who knows you or cares about you.
Right. I
to
mean,
someone the court knows.
well, yeah, it could be, it could still could be your children, it could be a
Okay.
family member, but now it's up to the court to determine whether that person is an appropriate, guardian for you. And then there's all of these other responsibilities that the guardian now has to do. So
Hmm.
you can avoid the guardianship path,
Yeah.
avoid it. Yeah.
All right. Good thought. Really good thoughts, Dawn. With that, Dawn, we're going to say thank you for joining us, and all you folks, really glad you came and visited with us again. Please click the like and subscribe button, click the bell, and most importantly, have a great day. We'll see you next time.
Thanks, Peter.